Okay, hey, thanks for joining us. We're here to talk about 10 things that everyone should know before
they file bankruptcy.
My name is Dwayne Farnsworth, and this is my friend, my colleague, my partner,
JC Cox.
And I've taken most of the speaking, so I'm going to let JC do a little bit of talking at this point. We're here, first of all, to look at the continuum of options that are out there or alternatives to filing for bankruptcy. Debt relief options go beyond just filing a Chapter 7 or Chapter 13 bankruptcy. So the first option is really not much of an option. Basically, not everybody needs to file for bankruptcy. You know what? We've got to get rid of the phone. So we're gonna.
But there's someone calling who needs a little help. So, just a second, we're gonna go help them out.
We'll be with you in a minute.
And we're back. We just filed 3 Chapter 7s.
Yeah, just want to keep rolling.
Okay, keep everything rolling. Here we go. Okay. Thanks for joining us. We're here to talk to you about 10 things that everyone should know before
they file for bankruptcy.
My name is Dwayne Farnsworth.
And I'm JC Cox.
And we're here to teach you together because sometimes there's just some things that JC knows that I don't. He's smarter than me, better looking, a little bit taller. But other than that, I'm just here to make sure that he treats you well.
But he has a better beard.
Yeah, well, there we go.
And more hair.
And now, debt relief alternatives. Debt relief alternatives go along a continuum. First of all, you might not need to have a bankruptcy at all. Sometimes people just need to realize that their income is Social Security income that can't be taken, and their assets are all exemptable or protectable. Other than the relief or the peace that comes from not having creditors calling you all the time, doing nothing is a viable alternative. Now, along that continuum, the next option would be
a debt management plan. The debt management plan, you work with a third party who goes out and negotiates with your creditors to come up with some type of a plan where you're making a monthly payment that goes towards paying down your debt. And now, normally that's going to be you figure out your budget, your normal expenses, and the payment that you're making is after you have put food on the table and made the house payment or the rent payment and your car insurance and those things. And what's left then goes to this debt management plan. Now, interest continues to accrue unless that's part of the negotiation. Debt management plans, though, you really need to be careful about who you work with. There are a lot of companies out there. There are also attorneys that do it. There are a lot of people out there that'll take your money without providing the service you need and put you in a much worse situation than you were when you started. They're crooks.
Well, a lot of the debt management plans came from the credit counseling services that were set up by banks in the 50s, 40s, and 50s. And they did a real good job up until the mid-90s. And then a lot of private companies came in and started taking them over, and it became a for-profit business. So JC's right. You need to be very careful with debt management plan operators, but even more so with debt settlement plans, and that's different. What they do is they ask you to make monthly payments in, maybe $800 a month for 10 months, and they'll save that money up, and then they'll go out and they'll make an offer to one of your credit card companies and try to get them to settle. And if they won't settle, then they'll move to the next credit card company. What they don't tell you is a lot of times out of the $8,000 that you put in up front, they're going to ask for $4,000 of it to be paid to them whether they're successful at this or not. And the reality is what they're not going to tell you is that before it all completes out in terms of dealing with all of your creditors, it's going to unravel. Some of these credit card companies are going to sue and get a judgment and want to start garnishing your wages. So debt management plan is one thing. A debt settlement plan, something you can do yourself. You can do with the help of a law firm. We certainly do debt settlements. And you can also then go hire a group out there that advertises on national radio and charges a lot of money for not really getting you where you need to get. If you think some of the debt management people are crooks,
You're right. Debt settlement can be a cesspool if you're not very careful.
There was new legislation that was passed by Congress 3 years ago specifically to address this because it became such a big problem. Now, moving along the continuum then is a Chapter 7 liquidation bankruptcy proceeding.
So in a Chapter 7, the purpose of a Chapter 7 is to get a discharge, which means when you get a discharge in a Chapter 7, the federal court, U.S. federal court, has said your creditors who are dischargeable can no longer try and collect those debts from you. Before you get to the point of getting a discharge, though, there's a lot of things that have to be known and understood. First of all, you have to find out, are you eligible to file a Chapter 7 bankruptcy based on your income, previous bankruptcy filings? You also need to know what kind of assets you own, what kind of debts you have, to know whether you're going to get the benefit that you need to receive from a bankruptcy, namely getting rid of the debts that you have, because not all debts are dischargeable. And also making sure that the assets that you have, that you don't potentially lose something that is critical to you going into the bankruptcy, like a business or a home that maybe you're behind on, those types of things. So what you own and who you owe are very important to know going in. Now, some of the things that happen immediately when you file a bankruptcy, either a 7 or a 13, there's a protection that goes into place called the automatic stay. So
That we're going to talk about later.
yeah, all the creditors have to back off.
Yeah.
And give you the opportunity to work through. There's a hearing that you have to attend with the bankruptcy trustee assigned to your case.
We're going to talk about that later too.
And these are all parts of the normal process. Normally, in a Chapter 7, you're looking at it, getting your discharge if everything goes to plan, right, unless you have some complications, in about 3 to 5 months on average.
And we're not going to talk about that ever again. Okay, Chapter 13 bankruptcy in the very simplest sense is it's a repayment plan based upon your ability to repay over a 3 to 5 year period of time. It allows us to do things like JC mentioned. I don't file a Chapter 7 bankruptcy for a client of mine who owns a business and they want to keep the business unless it's just purely personal service. If you're an accountant and you're willing to shut down your business and you don't have any accounts receivables, you can start up a new business real easily. But if you have a painting contracting business with lots of trucks and employees and you're probably wondering, why are you filing for bankruptcy? You have lots of employees and trucks, but trust me, it happens.
It happens.
Then we're going to use a Chapter 13 bankruptcy because a Chapter 13 trustee does not come in and assert control of your assets. The Chapter 13 trustee sits back and goes, okay, what does Dwayne have to pay to his creditors in his Chapter 13 bankruptcy to keep us from taking the stuff and like we would in a Chapter 7? Chapter 13 bankruptcy, we can also cure mortgage arrears in our home. If we're behind on our house and we file a Chapter 7, we're going to...
You're likely on the track to lose that house.
That's right. But if we're behind on our house and we file a Chapter 13 and we can afford to make the regular payments as they come due and make a Chapter 13 plan payment, we're going to save the house.
You're going to keep the house.
Okay, same thing with a car, same thing. Well, another issue is that the state law that we're going to talk about later, the exemption law, protects certain exemptable assets. Now, if we can't protect the entire asset, but we just cannot lose it, then a Chapter 13 will allow us to keep that asset. There's a lot of good reasons for a Chapter 13. It's a great piece of legislation. It's a great piece of social legislation that I like to implement when it's necessary, but usually I look at a Chapter 7 once we've decided we need to file for bankruptcy. Okay, so hey, thanks for being with us, staying with us. We've got some more materials to share with you later, and I hope you stay with the reading. I hope you stay with the moving forward in some of the progression of some of the videos that we'll have. I think when you get done with reading 10 things that everyone should know before
They file bankruptcy.
you'll be better prepared to determine what would be best in your financial life.
Know your options.
He wanted to say the last words.
Always have to.
Okay.